Cool. Okay, so welcome to today's webinar. It's our fourth episode in the series where we are talking about learning from data breaches. This is typically a shorter session than our normal webinars because they are a couple of lessons that we're going to learn from the two breaches that I'm going to talk about in detail. So I'll be probably finishing within half an hour. The session is being recorded, so if anyone does need to drop off, the recording will be available to you on our YouTube channel afterwards. So my name is Kelly Peters, co-founder of Data Basics. Today, talking to you about two data breaches. So the breach stories I want to cover are the UK law firm that was fined by the Information Commissioner's Office £98,000 because of a ransomware attack. And then I want to talk about what the Irish Information Commissioner found Meta to be at fault at, in that they were fined 17 million euros for breaching data protection. So if it's okay with everybody, I'm just going to launch directly into the lessons that we can learn. So quick question for everybody that's on the webinar. Who heard about the Tucker's law firm breach or the notification from the Information Commissioner that they'd fined this law firm? It's okay if the answer's no, that's not a problem. But did anyone read anything about this prior to today's webinar? Okay, that's cool. So Tucker's is and it describes itself on their website as the UK's leading criminal defence lawyers. They specialise in criminal law, civil liberties and regulatory proceedings. They've been established for almost 40 years and they have offices throughout the UK. So the first thing to point out that the UK hasn't issued many fines under the UK GDPR, whereas our European counterparts have been prolific. This has been only probably the fifth GDPR fine that has been issued. And it's one of the smallest that has been issued. But let's talk about the breach so I can give you a bit of context to it. So on the 24th of August 2020, obviously this is 2 years ago, and just to remind everybody that when the Information Commissioner investigates a breach, it can take a significant amount of time for them to come to a decision about whether or not an enforcement notice is going to be issued and a monetary fine will then be issued. So we have had COVID, but typically this 18-month period is what we do see. So on the 24th of August 2020, the law firm determined that it had been subject to a ransomware attack. This is because the IT team identified that it had been what they classed as a breach because certain elements of their infrastructure had become unavailable. And what they had found was a ransomware note from the attackers to say that their system had been compromised. So quite quickly, and this is something that has been highlighted as a good thing, the firm notified the Information Commissioner on the 25th. So just to remind everybody that is either listening today or listening to the recording, the organisation has 72 hours from the point that they become aware that there has been a data breach to report the data breach to the Information Commissioner. So the 25th of August, within 24 hours, the firm did report that they'd had a data breach to the Information Commissioner. So Tucker's explained that the attack had resulted in the encryption of civil and criminal legal case bundles stored on an archive server. Backups were also encrypted by the attacker. So what this was that there was a number of systems, but it was only the archive server that had been affected. There were just under 1 million individual files encrypted. 24,000 of those related to court bundles. 60 were taken from the system and published onto the dark web. So you might be thinking, oh, actually, that doesn't sound too much because it's only 60 bundles. But what you then take into consideration is that within those files that were published into the dark web, it contained medical files, there were witness statements, there were names and addresses of witnesses and victims, and there obviously was details about the alleged crimes that were the individual was being accused of doing. So the other point to note here is that not all of these cases were live. In actual fact, because the data was on an archive server, a lot of the cases had been concluded. So even though the information had been published onto a dark web, the data itself was related to cases that had been closed. Needless to say, because of the sensitivity of the nature of the data, and when we are weighing up a data breach, we need to weigh up the impact on an individual's privacy, whether it be emotional distress, financial distress, or physical harm. You can clearly argue here that the data that had been exposed could cause significant emotional distress to the individuals. So, quite a lot of data, but on a positive note, if there's any positives to take from this, it was just the archive server. What Tuckers were able to explain to the Information Commissioner that their live case management system had not been affected by this. So, as part of the investigation process, what happened was that Tuckers actually invited in a third-party organization to come in and really kind of understand what was going on, was able to work out how did this actually happen, what was the cause of the attack. So what this cyber security company were able to look at was, where did the vulnerability come from? How did it happen? What was the main issue that caused this ransomware attack to actually happen, so that, could the law firm then address it and make sure that measures had been resolved. Now, unfortunately for the law firm, the security investigators were not able to conclusively determine what was the cause of the problem. However, and it was redacted on the report, there was an identification that the server, the archive server, whatever software is running on that archive server, there had been an issue with the software. The vendor of the software that's running on the server had notified the public in December of 2019 that they had identified a known vulnerability, and that they were encouraging all of their customers to apply a patch. Now, the company, the software system, pushed out an update to rectify the vulnerability in January of 2020. Unfortunately, Tuckers didn't actually apply the update to the vulnerability until June of that year. So there was a significant period of time where there had been a known vulnerability, there was a patch that had been released that could have been applied that hadn't been applied. Now, what this actually enabled the attacker to do was they allowed the attacker to infiltrate the network. They were able to create their own account, and they were able then to deploy their own tools to be able then to encrypt the data and to hold the firm to ransom for the incident. The other point to note is that the investigators did identify that the archive server itself, the data on it was not encrypted. So actually, the data that was stored on the archive server, medical information, witness statements, information about victims, information about the accusers, information about, the crimes itself, were not encrypted. So actually, it allowed the attacker to access this data and then put the ransomware software around it. So this then led to the Information Commissioner making actually some really kind of strong recommendations to the law firm. So what we've got here is we have an archive server that's been accessed by a third-party attacker. They've been able to access a large volume of records. They've been able to exfiltrate 60 of those bundle files, publish them onto the dark web. And the reality is in the ICO's view, is that this could have been addressed. This risk could have been mitigated had the law firm actually patched the software vulnerability when the software vulnerability was announced. So, like I said, there was a known vulnerability. Patch was released in 2020. The firm didn't update it until June 2020. And to exacerbate this, the National Cybersecurity Centre in the UK, along with the US, actually published an announcement onto the web to say, this is a vulnerability, plug it, make sure it's been addressed. So what's the lesson that we can learn from this? Is that if you get notified by a software vendor that they've identified a known vulnerability on a system that you are using and that they have applied a patch and they have made this available to you, then as long as you have determined what are the relevant technical vulnerabilities, you've identified when you're going to apply this and you apply it, you're in a good position. So I'm not saying you immediately apply it, because you might want to test the patch to make sure it doesn't have any knock-on effects to the systems and its operating procedures. But no, the software vendors sign up to their newsletters, make sure that they are telling you when updates are being published, and then decide as quickly as possible to apply the change, especially if the National Cybersecurity Centre have identified critical vulnerabilities on software systems that they are then indicating should be addressed. Now, I appreciate in some instances there might be costs associated with applying a patch, but in this case, the patch was made available free of charge. So there was no reason why this system should have been left vulnerable for 6 months. So everybody that's on this webinar and anyone that's listening to it afterwards, do keep an eye on updates to any of the systems that you're using. Make sure that when patches are made available, you have a plan in place to apply those patches so that you can plug any vulnerabilities that are in the system. So that's the first one, patch management. The second one is two-factor authentication. So the law firm stated that even in their data protection policy that it required two-factor authentication, yet it was not used. So their policy that they rolled out to all of their staff stated that two-factor authentication should be something that is used, yet it hadn't been fully deployed. The ICO actually then went and referenced what they class as best practice, and they referenced the ISO 27001 standard. And it said that strong authentication should be in place, especially when we're talking about highly sensitive information. So multi-factor authentication is you're putting in a login and a password, you'll then get a text message to a mobile phone. So there are two different devices that are authenticating that you are who you say you are. obviously text message is just one of those means of doing that multi-factor authentication. And on top of that, because this is a law firm that is managed by the SRA, their guidance, published in 2018, said that multi-factor authentication should be deployed where possible. So again, the lesson that can be learned is if you have the ability to push out two-factor authentication or multi-factor authentication, do. And consider the data that we're talking about that is stored in the systems that is offering you 2FA. So look at your systems. Is multi-factor authentication available? If so, what data are you processing? When could you roll that out? Because it could prevent an incident such as this occurring to you. So what the report said into Tucker's was that taking into consideration the highly sensitive nature of the data, remember these are bundles that contain court documents that Turner's was processing, as well as the fact that multi-factor authentication is available, it's not overly expensive to implement, this risk should not have occurred simply because of using a single username and password. And in the eyes of the ICO, their statement was it did not ensure appropriate security, including protection against unauthorized and unlawful processing of personal data as required under the regulation. So we've got data, we've got a system that should have been patched that hadn't been patched. Access to the system shouldn't have been made available because actually rather than using a login and password, there should have been multi-factor authentication. So 2 lessons here. And for you, think about your systems. Have you put in appropriate measures to protect your systems from external threats? Is multi-factor authentication available? If yes, has it been deployed? If not, why not? And definitely make sure that your policies that you have align with your actual practices. So don't say you're doing one thing in a policy and then not be doing it in practice. So what we then have is the final lesson here is about data encryption. So the ICO made a statement to say, actually, we acknowledge actually the main cause of this was an external third party accessing the systems. However, whilst the majority of the systems in use, in particular live cases on the case management system, were not affected, the server that had these archived case bundles on it did not put on any data encryption. So there was no additional protection put in place on these files to prevent a third party accessing them. So encryption would make it kind of, without a decryption key, would make actually it unreadable. Now, the commissioner made this point to say that the data protection policy that the firm had identified client data as its most sensitive, yet it didn't employ the most rigorous measures applicable to that type of data. So you're almost inviting the opportunity for this threat to happen. Effective encryption management actually isn't massively expensive today. It can help reduce the risk of a ransomware attack. And in actual fact, the commissioner themselves published guidance on encryption that states it considers encryption to be an appropriate technical measure when processing, special category data. So for me, the lesson that we can look here is, you now know, we've talked about your systems. I'm sure all of you know where your data is stored and where it's processed, but on the servers where it is sitting, is it still protected? Have you employed a level of encryption on those data files, especially where we're talking about the most sensitive type of data? So a lesson to take away if you don't know if you're using encryption on servers is to find out, um, can we do it? If so, what is the cost involved in that? It shouldn't be massively expensive. And again, it's an additional risk prevention measure that you can deploy. So before I move on to the next case, are there any comments that anyone wants to make on this? Any views or anything that people want to say? Oh, this is something I'm going to go and take away and look at. I can see some typing going on, so I'll give it. So it's a really good question. How do you know if it's been published on the dark web? So there are tools out there, lots of, if you have an IT provider, IT providers can actively scan the dark web, and they can put filters out there so it can identify whether or not data that relating to you has been published. So whilst you may not be able to do it yourself, and I'm sure if you went on to Google or YouTube, you'd be able to find out how to do it. But certainly if you have internal or external IT professionals, a lot of them do actively scan the dark web today to be able to see if there are any of their data. And I certainly know that, more and more are doing it today because of the amount of data that's being published. So I would say go speak to your IT provider to say, do you check the dark web? If so, how do you do it? And how would you notify me if our data had been made available? Any other comments before I summarize what the ICO had to say on this matter? No? Okay. Let me so what the I think I think it's good that you're able to identify that have been attempted attacks, and they're actually because of appropriate software, it was a deterrent. And then obviously you've added additional measures in place in terms of the two-factor authentication and then VPN. So good, I'm glad. So what we've also got here is that the ICO concluded that Tucker's failed to implement appropriate technical and organizational measures. So this is, Article 5, 1F, over some or all of the relevant period rendered it vulnerable to attack. So over that 5-month period, they made themselves incredibly vulnerable, and they were then exploited for that. So the reason I wanted to talk about this story today is that a lot of people typically think it's large global firms that get fined. In actual fact, whilst it is a relatively large law firm in the UK, they were fined a significant amount of money for what amounted to a very small amount of data overall that had been made public. So bear that in mind. So the only other lesson I'd say on this is do go back, review your systems, make sure that you have appropriate measures in place for the data that you are processing, because you don't want to be made vulnerable. Excellent. So just to cap on the comment that we got here is that there is an easy guessable account for a copier. Don't forget other systems that are connected to your network, and make sure you have appropriate passwords, because through such as photocopiers or printers, any device that is potentially connected to your network could be made vulnerable. So do think, not just when I talk about patch management, don't just think about servers, think about devices that are also connected to your systems. So finally, I really wanted to touch on, and this is, there's not been massive amount of information that's been published on this, but yes, it is a global conglomerate. It's very different for the breach that I have just talked about. You know, they're classed as one of the big five. They changed their name from Facebook to Meta because they want to really focus on this metaverse that they're creating. But they were fined by the Irish Data Protection Commissioner 17 million euros, or they intend to fine Meta 17 million euros. Now, this fine was a decision across multiple European jurisdictions because Facebook operate globally, but because they are based in Ireland, the Irish DPC took the lead on this. And remember that Facebook is Facebook, Instagram, WhatsApp, and a whole raft of other elements. So the Irish Data Protection Commissioner decided to take action because they had received 12 data breach notifications in a course of a 6-month period. So whereas the previous one, the firm had notified the Commissioner of a breach, this is other individuals making complaints to the Information Commissioner that breaches had occurred. So this is not Facebook reporting it. This is other people and the Commissioner taking notice that, hold up a second, there's a number of breaches that have been reported, and there have been no notifications from the firm. There is a stipulation within the regulation that says if you fail to report a data breach to the Information Commissioner, they can then impose a separate fine on you for failing to notify data breaches. So very similar to the previous breach, the Irish Data Protection Commissioner concluded that Meta failed to put appropriate technical and organisational measures in place. And more importantly, they failed to be able to demonstrate that. So let's not forget the accountability principle that exists or underpins the core principles of the regulation. So this is the only lesson that we can really draw from this, is that you are, as organizations, required to demonstrate accountability. So what evidence could you provide to the Commissioner if they're investigating you for a breach? So how do you demonstrate that you've got patch management in place? How do you demonstrate that you train your staff? How do you demonstrate that you routinely review your register of processing activities? So what measures do you have in place that, should you get asked, you can present the information? And Facebook were unable to provide the Commissioner with sufficient evidence that they were fairly and lawfully processing data. They had appropriate technical and organisational measures in place. And let's not forget, whilst it wasn't mentioned, that you can also be fined to be breach of the regulation for failing to store data for longer than is necessary, or holding on for it too long, holding too much information, or storing it and processing it for multiple purposes. So the key lesson here is demonstrating accountability, and accountability is across the whole supply chain. So don't just forget about yourself. As has already been mentioned here, if you have third parties that you're working with, do you have contracts and conditions in place? So if they're responsible for any of your systems and processes, how are they supporting you with making sure that they are compliant with the legislation? So accountability, can't emphasize it enough, incredibly important. That was very much a whistle-stop tour. I didn't want to focus too much on it, but I wanted to emphasize the accountability. And I'm sure everybody on this webinar is familiar with accountability. If not, one of our previous webinars, I did talk about the accountability tools that you can use to help support your compliance program. So before I ask, are there any other comments that anyone wants to or any reviews or points they want to share with me about this particular case. Apologies for my coughing. Okay, I did say I'd keep this to half an hour. Okay, any questions that anyone has or would like me to answer, even if I can speak properly today? No? Okay, I'll let some typing going on. So just to recap, if you want a half an hour call with me free of charge to talk about any of your data protection or privacy concerns, you can do. You can ping me an email. We have our catalogue that's available on our website, which provides all of our fantastic products and services. If any of you are interested in joining at one of our best practice groups, they are free of charge and they're a great way of being able to share in a very secure space any data protection concerns that you might have. Do follow us on all of our social channels. So do keep in touch with us via our website, sign up for our newsletter if you haven't already, and connect with us on LinkedIn. So thank you very much for your attention today. I hope you all have a good rest of today. If there aren't any other questions, the recording will be made available next week, which is the beginning of May. You know where I am if you have any questions. So thank you for your time and attention, and I hope to see you on a future webinar.